Assalamualaikum warahmatullahi wabarakatuh. Shalom, Namo Buddhaya, Om Swastiastu. Distinguished committee members, fellow presenters, and participants. My name is Putu Laksmi Sasmita Dewi from Universitas Pendidikan Ganesha. Today, I am presenting our study titled The Implementation of Sustainable Development Principles within Indonesia's National Legal System, Challenges and Pathway Toward a Green Society. Ladies and gentlemen, sustainable development has become a major global priority, especially after the adoption of the Sustainable Development Goals in 2015. As illustrated in the introduction section of our paper, the world continues to face critical pressures such as climate change, environmental degradation, and socio-economic inequality. These challenges make it increasingly urgent for states to transform toward what we call green society. A society built on sustainable behavior, clean energy, responsible production, and effective environmental governance. This transformation requires strong legal foundation and coherent policies. In Indonesia, sustainability principles are embedded normatively within several major legal instruments, including the 1945 Constitution of the Republik Indonesia, Law on Environmental Protection and Management, Law on Job Creation, RPJMN and NDC commitments. However, as our study emphasized, despite a strong normative foundation, Indonesia still faces weak and fragmented implementation of the sustainability principles. Before identifying the research gap, it is essential to recognize that exciting studies have explored many aspects of environmental governance. However, despite this growing body of literature, several critical issues remain unaddressed. Previous studies often focus on sectoral problems such as coordination issues, regulatory overlap, and enforcement failures. However, very few studies critically analyze the shift toward administrative formalism in environmental instruments such as AMDAL and environmental licensing following the Job Creation Law. Likewise, research connecting normative frameworks with judicial practice remains limited. This gap is what our study seeks to address. From the research objectives, our study aims to, first, evaluate how sustainability principles are integrated into Indonesia's legal framework. Second, identify regulatory, institutional, and political barriers. And third, recommends pathway to strengthen environmental governance. On research method, we use a normative juridical method, relying on analyzing constitutional provision, environmental statutes, government regulation, and judicial decision. Primary sources include the 1945 Constitution, Law Number 32, 2009, Law Number 11, 2020. Government Regulation Number 22, 2021, and several landmark cases, including PT Dairi Prima Mineral, PT UN Jakarta 159/G/LH/2023, Walhi versus PT Kusuma Raya Utama 44/PD.G/LH/2018. Secondary sources include academic journals, legal reports, and relevant literature. Before I move on to presenting the key finding of the study, allow me to first provide a brief overview of how these findings were derived. After analyzing Indonesia's legal framework, key sectoral regulation, policy instrument, and judicial decision using the normative juridical method, several major patterns and structural issues began to emerge. This pattern revealed not only how sustainability principles are positioned within Indonesia's legal system, but also how they function or fail to function in practice. Therefore, in the following section, I will present the core result of this research, which summarizes the gaps between normative expectation and practical implementation. With that, I now proceed to the main findings of our study. First, strong normative basis for sustainability but weak translation into practice. Our analysis finds that although Indonesia possesses a robust constitutional and statutory framework for sustainable development, these legal principles have not been consistently operationalized across implementing regulation. It means, although Indonesia has a comprehensive legal framework, it has not been effectively translated into coherent policies or institutional practice. Second, fragmented regulations and sectoral incoherence undermine effective implementation. Disharmony between environmental, spatial planning, and economic sector regulation creates inconsistencies that weaken ecological protection and hinder unified policies execution. Third, environmental enforcement remains procedural rather than substantive. Instruments such as AMDAL and risk-based licensing are frequently treated as administrative formalities, rather than mechanism for rigorous ecological risk assessment and meaningful public participation. And the last one is judicial decision reveal inconsistent application of sustainability principles. Court rulings vary widely, with some adopting progressive ecological reasoning while others rely on narrow administrative interpretation, showing that judicial understanding of sustainability remains uneven. These cases provide concrete illustration of how sustainability principles are implemented or overlooked in practice. They help us understand how the normative framework operates when tested in real legal disputes. Case number 1, PT Dairy Prima Mineral. The court annulled the company's environmental feasibility decree due to absence of mandatory disaster risk analysis, ignoring the precautionary principle despite geological risk, spatial planning violation, and insufficient public participation under Article 26 of the Environmental Law. This case demonstrates how environmental licensing often prioritized administrative completeness over scientific and ecological accuracy. Case number 2, Walhi versus PT Kusuma Raya Utama. Although the company met administrative requirements, field evidence showed that the mining inside a conservation area, land subsidence and ecological damage, superficial government inspection with no underground assessment. This case highlights the gap between administrative compliance and substantive environmental protection. As we reach the end of this presentation, it is important to briefly tie together the key points discussed. The following conclusions summarize the overall insight and the broader implication of the study. And the conclusion is, the study concludes that although Indonesia possesses a strong normative foundation for sustainable development, its implementation remains inconsistent due to regulatory fragmentation, weak coordination, procedural environmental enforcement, and limited supervisory capacity. The cases of PT Daily Prima Mineral and Walhi versus PT Kusuma Raya Utama further demonstrate systemic gaps between administrative compliance and actual ecological protection, revealing failures in applying the precautionary principle, spatial planning, and substantive monitoring. These findings show that achieving sustainability requires not only robust legal norms but also improved governance, performance, cross-sectoral policy integration, and institutional commitment to ecosystem protection and meaningful public participation. Strengthening risk-based permitting, enhancing supervisory capacity, deepening community involvement, and developing judicial guidelines are essential steps to ensure that Indonesia's legal system function effectively in supporting this transition towards sustainable development. Thank you very much for your attention. I hope this presentation provide meaningful insight into challenges and opportunities strengthening sustainable development within Indonesia's legal system. I welcome any question, comments, or further discussion. Wassalamualaikum warahmatullahi wabarakatuh. Om Santi 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 Om.